So DPP Gonga is abusing his office. He's showing his incompetence in handling criminal justice. And we must say it for what it is.
Okay.
He is acting as a lackey of the legacy politicians who are uncomfortable with the citizens expressing themselves in the manner provided in the Constitution. Look, even the Homa Bay 8, you are dragging poor villagers from Homa Bay who have never stepped in Nairobi to take them to Kahawa Court that was set up for charging people who had committed serious acts of terrorism. Those people who are just mourning their colleague who was brutally murdered by the police in a police cell, you drag them from Homa Bay, go and charge them in Kahawa. That is wrong. It infringes on the constitutional rights of those individuals. These trials are not meant to serve the interest of justice. These trials are meant to punish these young people. You are using or abusing the criminal justice system to mete out a punishment on the young people before they are tried, knowing very well that if they went through a fair process, they will be acquitted of those fake charges. So what do? You want them to be punished by taking them through that entire nonsense. That is what is going on. When you impose cash bail of 100,000, what informs that decision to impose that kind of enormous amount of money to these young people who you can clearly see? These are jobless young men.
Very good day to you, ladies and gentlemen. Welcome to another episode of the Candy Talk here on Herman Manyora's YouTube channel. My name is Evan Sokinyi, and it's my pleasure to have you on board. I'm here with my resident guest, the very able Wakili Willie Sotieno, who is the Deputy Party Leader of Safina Party, Deputy Presidential candidate, of course. Whether I don't know whether to call him Deputy President Designate, as he usually refers to himself here. Wakili, is that the case?
Designate.
Designate. You already see yourself there.
Designate.
Okay. I want us to focus on what is actually happening in the country. Of course, after the recent killings during the Sabasaba protest, a lot is actually happening. One, we've got terrorism charges, which the state has now decided to put forth against the protesters who were arrested at that particular time. A lot is also happening, others being accused of robbery with violence, but also we've got a lot to do with the inquest into the Rex Masai's murder, what happened therein, and the call for accountability. I want us to begin from the state's action to decide to charge these protesters with terrorism, and then look at the kind of bail terms that have been put therein by the courts as well. Parents crying left, right, and center.
The first person we need to condemn and call him out is the DPP, Igonga. Why are they registering these fake charge sheets in court? Because ask yourself, if these were just demonstrators, protesters, why are you charging them under the Prevention of Terrorism Act? It is profiling. It is meant to cause fear. In fact, that is the act of terror that is being committed by the state. To try to terrorize citizens who are exercising their rights under Article 37 of the Constitution by levying charges which are illegal on them. You want to profile them so that on their record, they'll always have a record showing you are charged for an act of terror. Terrorism is not something to be played around with the way William Ruto'S regime and DPP Gonga are doing. Terrorism is a serious act, condemned nationally, and attracts a national ire. Here now they are throwing it like confetti for the sole purpose of undermining the people's rights to peaceably and armed to demonstrate. So DPP Gonga is abusing his office. He's showing his incompetence in handling criminal justice. And we must say it for what it is. He is acting as a lackey of the legacy politicians who are uncomfortable with the citizens expressing themselves in the manner provided in the Constitution. Look, even the Homa Bay 8, you are dragging poor villagers from Homa Bay who have never stepped in Nairobi to take them to Kahawa Court that was set up for charging people who had committed serious acts of terrorism. those people who are just mourning their colleague was brutally murdered by the police in a police cell, you drag them from Homa Bay, go and charge them in Kahawa. That is wrong. It infringes on the constitutional rights of those individuals. Even assuming that you wanted to charge them for any offense for that matter. Why are you charging them in Nairobi? Why not in Oyugi's court? Why not in Kisii? Why not in Homa Bay Town Court? Why Nairobi? The Constitution, number one, gives you the presumption of innocence to every accused person. And Article 50 requires of you to be given adequate facilities to prepare for your defense.
Okay.
When the scene of crime is allegedly Homa Bay, and you drag this gentleman to charge him over 300 kilometers away in Nairobi, how are you giving him an opportunity to adequately prepare for his defense? You're essentially abusing state power to bear upon the individual, deny him an opportunity to competently respond to the allegations you made against him by charging him in a court where you know, number one, he's going to incur costs to attend to court. Or in the alternative, you intend for him to one day jump bail. If he lives in Homa Bay, so it means he has to be taking vehicles to come to Nairobi. So he has to incur cost to attend court. If he can't, if he misses his bus, or doesn't have the money to come to court, you will ask the same magistrate to issue warrants of arrest. You will go and arrest him, and then now ask that he be committed to remand for the entire duration of the trial. So that system is designed purely to punish the people of Homa Bay.
Okay.
And those Homa Bay 8 are still presumed to be innocent. Look even at the quality of charges you are preventing against them. What did those young men do other than mourn their brother and give a press conference saying how they were angry at the manner in which Albert Ojwang had died? You respond by charging them for terrorism? No. That's abuse. When you talk of abuse of the criminal justice system, that is spectacular abuse by the DPP.
Okay. I want us to make our viewers understand this, because essentially this is not the first time we're having these protests in this country. We've had them before, and protesters have always been arrested and taken to various courts, and others have been released either on free bond or something of the sort, or some lenient amount of money therein. But then for the Kahawa Law Courts, a court that has not been in the limelight for quite some time, owing to the nature, what sort of crimes should actually be presented at that particular
No, the first step is this. The Kahawa Magistrates Court is a magistrates court like any other. But it was specially designated purely because of security reasons to deal with terror suspects. And we are not talking of terror suspects in the ilk of the Homa Bay 8 or the Thika accused or the Limuru 2. No. That court was designed for Al-Shabaabs, the Al-Qaedas, that we are going to put it in a secure location. We provide sufficient security to enable us to conduct a trial without giving an opportunity for the sympathizers of these terrorists to access and maybe force them a prison break, kind of.
Okay.
That is why Kahawa Court was set up. It does not mean that it's the only court in this country that has jurisdiction to try under the Prevention of Terrorism Act. It does not mean. Even that court in Homa Bay can try for it.
Okay.
It was just a specially secured court to target those serious terrorists that there may be a real fear that the accomplices who are out there can attack an ordinary court to secure their release. But what are we witnessing now? When that court was being designated as a court, did we have in mind the innocent young people that we are now seeing being dragged to that court every day? From Homa Bay, from Limuru, from Thika, some from Nairobi, to be charged with nonsense. This is abuse, and the judiciary also must be called to account. Why are they entertaining charges in only one station when we have courts all over the country? Why are we financing those courts? Let the DPP go and make a mockery of himself in Oyugi's court. In the same Oyugi's court, These young men had been charged. In Oyugis. The court released them on free bond.
What's the relationship between how the office of the Director of Public Prosecutions work and the judiciary? Because here is a case whereby we may be blaming the judiciary, but then...
we are not blaming the judiciary. We are simply saying, ultimately, when a charge is registered, it's the court that invites the accused person to take plea.
Okay.
And from the facts and information provided, the court can tell that this offense are alleged to have been committed in Homa Bay. The court has known us to say, no, we are not admitting this charge sheet.
Okay.
Go and register it in Homa Bay.
Okay.
They can do it.
So the judiciary can
It has
actually
been
direct
done
the
before.
ODPP
Yes.
to take that to another court.
Yes.
Can handle such.
And has been done before.
Okay.
It has been done before in so many cases. Why are they not doing it for these ones? They cannot hide behind that they are neutral. In situations of violation of rights, in situations of oppression, your neutrality or silence means you are taking the side of the oppressor. You are now part of the oppression. They have a right to say, no, we are not admitting this particular one. Take it to Oyugis. I'm not admitting the charge sheet as proposed. What reason do you have to bring them? If you claim that it's about security of the accused persons, then don't charge them in Oyugis. Go and charge them in Homa Bay. Go and charge them in Kisii High Court. Go and charge them in Kisumu.
Okay.
There are so many courts in the vicinity.
So what motive do you read from this deliberate attempt by the state now to
This
treat...
is purely a case of the state trying to clamp down on free speech, to clamp down on the right to peaceably and armed to demonstrate. These trials are not meant to serve the interest of justice. These trials are meant to punish these young people. You are using or abusing the criminal justice system to mete out a punishment on the young people before they are tried, knowing very well that if they went through a fair process, they will be acquitted of those fake charges. So what do? You want them to be punished by taking them through that entire nonsense. That is what is going on. When you impose cash bail of 100,000, what informs that decision to impose that kind of onerous amount of money to these young people who you can clearly see? These are jobless young men. These are people who should be given free bond. The courts have done it before. You can give somebody free bond and ask for his attendance to court. They will attend. But why bring it to Nairobi in a highly secured facility? It's punishment, even psychologically. It's part of psychological torture to drag these young men and women to Kahawa. It's meant to psychologically demoralize them.
Okay.
You are punishing them psychologically so that they are not able to even understand what is going on. You're actually instilling fear in them. It's inhumane, it is degrading, and it must be condemned.
Let's talk about what happened at the Thika Law Courts with parents wailing left, right, and center, trying to actually plead with the magistrate there to give their sons at least some sort of lenient bail terms. The amount of money that these young people are actually required to pay therein. I saw Senior Counsel Paul Mwite weigh in on this, and he's saying, yeah, look, the judiciary should not be behaving in a manner likely to suggest that they are an extension of the executive. I wonder what you make of this. Is the judiciary actually behaving in such a manner that would deem them so?
I will not condemn the entire judiciary because we have so many fair-minded judicial officers in the country, across the entire country, working tirelessly to serve the interest of the rule of law. But within the judiciary, we have elements, rotten elements, who are now turning to become gatekeepers of the executive. They are the ones who are perpetuating this oppression. They are admitting charge sheets that ideally they would not have admitted. They are allowing for trials to start in circumstances where a charge will not even be admitted. They are allowing bail terms and bond terms that are so onerous that are not meant to secure this attendance to court, that are meant to ensure that the accused person is remanded in custody. That is why you are seeing onerous bond terms. I've told you, these young men, when you're giving bail or bond, it is not meant to be a punishment. It is just meant to be your commitment to attend court That is the purpose of bail or bond, to ensure the attendance to court when required by an accused person. Remember, the accused person is innocent until proven guilty. So at the point of being bonded, you are still innocent. So the bail or bond is just your cognizance that if I don't attend, I will forfeit this. But warrants of arrest can be issued if you don't attend. And you'll be committed to remand. So when you, at outset, set up a very high amount as the cash bill, knowing very well the young man before you, or the young woman before you, cannot afford it, what are you telling? You're telling the young man, I'm not going to be fair to you. In fact, I want you to be punished by being denied your freedoms, by being taken to remand before your trial. So if you are kept in remand for 3 years, as you're going through the trial motions, and subsequently set free, acquitted, but you'll have stayed in remand for 3 years, your rights will have been violated. Your freedom will have been infringed.
Okay.
That is what they're doing. And the judiciary should not entertain this nonsense. And I encourage judicial officers, many of them who I know, are minded to apply the law and facts to circumstances before them, to not allow this kind of nonsense that DPP Gonga is now entertaining in the court corridors. They should reject these charge sheets. And they should even release these people on free bond. They will attend court. If they don't attend court, you can issue warrants.
Okay.
But in cases that I've been involved in, I can tell you for a fact, many of these young people attend court when they're required.
Okay.
I've never handled any one case that the person failed to attend court. They've attended court when required, and they've won those cases. In the fullness of time, you see the charges that are levied against these people are fake charges. Cannot get anywhere.
Finally, let's talk about the nature of these particular charges. Of course, we've talked about robbery with violence. We've seen that level against the young people who were arrested and presented at Thika law courts. But at the same time, we had a lot of activities happen during that particular day, including looting and destruction of property. How then are these people helped? Because at the end of the day, the government is expected to ensure that in as much as they protect lives and rights of protesters, they also protect the rights of those who are not participating, as well as property here being destroyed. So right now we are seeing protesters being charged with robbery with violence, but at the same time, we are not seeing the government doing enough to ensure that those particular individuals who looted supermarkets during that particular day are brought to book.
But those looters were sponsored by legacy politicians. The legacy politicians who sponsored those looters, they are known. The same government has not gone against to arrest them. Some of them recorded videos. Some of them were seen maiming and beating innocent Kenyans. Why have the police not gone for them? Why has DPP Gonga not directed for them to be prosecuted? Because they are all lackeys of William Ruto. They are William Ruto's poodles. They are doing everything within their powers to support a repressive regime. They are not serving the rule of law and the people of Kenya. They are serving William Ruto, and they want to make him happy. That is why if they threaten killings, when they go out with the rungus to beat, when they attack innocent civilians and rob them, nothing is done to them. They think that Kenyans are still children of a lesser God.
Okay.
They are not. And justice shall be served. In the fullness of time, I've always said, in the fullness of time, these police officers, these people are holding office today, they may have the watches, we have the time. We will have them arraigned in court.
Does it therefore mean that we may actually fail to see the real thugs and goons who looted these supermarkets?
But the legacy politicians who are protecting them are still in office. So once we get rid of the legacy politicians, we will call them. Remember, there is no limitation of action in criminal law. They will have their time to answer to all these atrocities.
Finally, as we wind up this show, still on the corridors of justice here and the clamor for accountability, looking at the inquest into the Rex Masai murder, I'm so sure you are well conversant with that particular case. Look at the response of the particular officer here who is being accused of pulling the trigger on that particular day, denying the images of himself. Really, what then happens in that particular moment?
No. The circumstantial evidence are all pointing to him. The image striking semblance of him. His phone that he's holding on the phone on his hand, he claims he didn't have a phone. The phone that he's holding is the same make that the phone that the IME number is showing us that phone is the same make of the phone he's holding in his hand. The phone is registered in his name. The birthmark next to the chin that appears on the image, he has the similar birthmark. So all the circumstantial evidence points out to him.
Okay.
And Muraguri is just bidding time. That time is up. In fact, if for a moment he thought he was helping himself, he's actually now reaffirmed that he's the one. When now the trial will start, remember he's made these statements under oath. These statements will be used against him. Having denied, and there's exculpatory evidence showing that it's actually him, then why was he lying? He's actually made the case easier for him when the time comes.
Okay.
When his trial starts, he's made his case very easy.
So then what happens when a suspect denies clearly that this is not me?
It's okay, he can deny.
No one can see that this is you.
The point is, he can deny, but we can also form our opinion. So in terms of credibility, we can all see he's a liar. Yeah.
Okay.
That's what I'm saying. The exculpatory evidence is showing it is him. His response, instead of explaining, he denied. So we are all wrong. Technology that captured him is wrong. The phone that is registered in his name is wrong. The phone that he's holding in his hand is wrong, but he's not able to give an explanation as to where he is and who was his alibi. So we are all wrong, but him is right.
Okay.
No, he's wrong.
So
he will be convicted when the time comes for his
all
trial.
these images that we're seeing here places him directly at the scene of crime. But then at the same time, is this enough to nail him? Because I understand that maybe, what then happens to the evidence on the bullet that was pulled? I mean,
he can still be convicted on the circumstantial evidence, even if the bullet is missing. Don't tell me that if the murder weapon is not there, you cannot convict someone of murder. You can. The circumstantial evidence will be sufficient to have him tried and convicted. And more so, to the extent that he's not able to explain. His response is not him, but where was he? Who is the alibi? Where is similar circumstantial evidence to corroborate his testimony? None.
Is his presence at the scene alone enough to have him convicted?
His presence at the scene alone and his conduct at the scene is enough to convict him.
How many police officers were at the
His
scene?
conduct in particular. We are not discussing the conduct of all police officers. We are discussing his particular conduct. And we have also eyewitnesses placing him on the scene. Don't just think it's just about the technology. There are eyewitnesses placing him on the scene. And those eyewitnesses can tell the story about his conduct. And their testimony is sufficient.
Okay.
And that testimony is corroborated by technology. He has to find similar eyewitnesses and technology to corroborate that is nonsense that he's saying today in court. He doesn't have it. He's just bidding time. His goose is cooked, man.
By the way, was the bullet recovered?
That is, I may not know.
And the forensic evidence
I may not
there?
know. But the main thing is, I've told you, you can be tried for murder even if the murder weapon was not found.
Okay.
As long as the postmortem shows that there was a dead person who died out of bullets. And you can also tell this is a police officer who has access to those kind of items. So,
Okay.
that's enough.
And just by the way, why was the other officer, the one who was with Barasa, let go by the court, by the ODPP? That is, he was not charged of murder after...
To the extent the person who pulled the trigger was seen. And there was evidence showing the person who pulled the trigger. The other officer just happened to be on the scene. He can actually become a witness against his colleague.
Okay.
Yeah. I saw him pull the trigger. He's a witness against his colleague. That is the fate of policemen now going forward.
Okay.
Their own colleagues will be witnesses. Once we are done with these legacy politicians, you will see policemen turn on each other like rats. That one will turn against his colleague.
In as much as he harassed the boy...
He harassed, but he didn't pull the trigger.
So the one who pulled
It was
the
not
trigger...
part of a criminal enterprise, the joint criminal enterprise between the two of them, to go and kill that young man. Na kila mtu ataubeba mzigo wake.
And that is why I was asking, what if this officer in Rex Masai's case say, I didn't pull the trigger?
He didn't pull the trigger, but he's present, and you have the eyewitnesses saying you did. Yeah, That's the why you have eyewitnesses. That's why you have the CCTV images showing him holding a gun.
Okay.
Or you've not seen those ones?
You've seen them.
Yes. So that's why there's more evidence corroborating he pulled the trigger.
Okay.
He's responsible.
So all these things happening in the country, of course, we are still at crossroads, and of course, the most important question is which way, Kenya, and how do we go look at these? The government giving different numbers. Of course, Murkomen talking of 42 people being killed, the human rights groups talking of 60 people having lost their lives, 60 plus, of course, during the Sabasaba movement. All this kind of confusion that we are witnessing in the country, we are asking now, what next for the country with regards to all this?
Ruto must go.
Can we have this conversation again? Have yourself a lovely day. My name is Evans. Okay, thank you for watching, ladies and gentlemen. And please, if at all you're watching us for the first time, subscribe to our channel here and tell us, what do you think about the events, what is happening in the country?